What does equal protection mean to students? Well, let's first take a look at what equal protection means. In 1868, the Equal Protection Clause of the 14th Amendment of the United States Constitution was created. The 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the laws. In other words, this means that a state and our federal government must treat an individual in the same manner as others in similar conditions and circumstances. When officials look at the Equal Protection Clause, they consider these three questions. What classification does a government action create? What level of scrutiny should be applied to this classification? And does this particular government action meet that level of scrutiny? An example of how this Equal Protection Clause was determined is first seen in the 1947 court case Mendez v. Westminster, which focused on the discrimination of Mexican-American children within a public school setting. Sylvia Mendez's father, Gonzalo Mendez, sued 4 Los Angeles area school districts when she was rejected by a California public school that stated it was for whites only. The court had ruled that segregation based on race within the public school setting was unconstitutional under the Equal Protection Clause. In addition, the Equal Protection Clause was later determined again in the 1954 court case Brown v. the Board of Education. This case was brought up to court through a combination of 4 cases and centered on the segregation of students in public schools on the basis of race. In each of the cases, African American minors had been denied admittance to certain public schools based on the previous ruling in Plessy v. Ferguson, which allowed public education to be segregated by race as long as it was equal. In the court ruling of this case, the term separate but equal was overturned, thus prohibiting the segregation of public education. Besides the Equal Protection Clause, there was another court ruling, Title VI of the Civil Rights Act of 1964, which helped strengthen the ideas expressed in the Equal Protection Clause. In fact, Title VI had essentially prohibited the discrimination of others based on race, color, and national origin in programs as well as activities that receive federal financial assistance. Due to the leverage of financial funds, individuals who receive them are required to comply with the rules of Title VI and not discriminate against others, or else they would have their funds halted by that federal agency. For example, in the 1978 court case Regents of University of California v. Bakke, the use of the Equal Protection Clause in Title VI is shown when Alan Bakke uses it to justify his demand for the removal of the admissions program. There were 2 admissions processes. The first one was a general one that decided based on GPA and test scores, while the other one decided based on race in order to fulfill the school's race quota. The court ruled that the university's admission program was unconstitutional because it violated both the Equal Protection Clause and Title VI, which resulted in the fact that the university could no longer limit individuals based on their race. Additionally, in 2003, there was another case, Gratz v. Bollinger, that challenged the Equal Protection Clause and Title VI. In this case, Gratz was extremely qualified for the University of Michigan's undergraduate College of Literature, Arts, and Sciences, yet she was denied admittance. The school system favored the minority population by allowing them easier admittance to the school, which Gratz felt was an injustice as she was a white woman. At the time, they used 2 different kinds of grid systems. The first one that took scores and GPAs into account to decide their admittance into the university, whereas the second one was intended to bring in students who qualified as underrepresented minorities. Eventually, that system was replaced with a point system, which used a system of 150 points for admissions into their school. Race became a decisive factor in the admissions process when the university automatically gave 20 points to any persons of racial minority. The Center of Individual Rights were the ones to file a lawsuit for Gratz against the University of Michigan's undergraduate admissions system, and in the final court case, the Supreme Court of the United States ruled that for Gratz, the grid system that had rejected her was unconstitutional, but the school's new point system was constitutional because it was a justified way to achieving a diverse student body. In conclusion, the 14th Amendment represents a lot of controversy that results from its several different interpretations. This is seen through the numerous cases that were discussed, as some of them contradicted each other's views on what the amendment means in relation to students.